Good morning. If you could please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States, to the republic which stands. Thank you. Please be seated. Good morning, everyone. I want to welcome you to the January 24th, 2022 Land Use Hearing Officer hearing. My name is Susan Finch, and I'll be presiding as the hearing officer over today's cases. Let me start by introducing Mr. Tom Hisney. He's to my left with the Development Services Department. He'll introduce other staff members and also go over changes to today's agenda. Mr. Hisney.
Yes, good morning. My name is Tom Hisney. I'm with Development Services staff. To my left is Carmen Mason. He's also with Development Services staff. During the course of the meeting, we will be joined by other members of Development Services virtually. They include Brian Grady, Tanya Chapella, Kim King, Sam Ball, and Kevy DeFranc. Also joining us today in the room is Joe Harless of BOCC Records. And we will also be joined virtually by Mary Dorman and Cameron Clark, who are assistant county attorneys. Changes to the agenda. We have one change that is not published. That is for item J1 on page 9, special use application 22-0240. The applicant is here to request a continuance.
All right. Good morning. Is the applicant here? Good morning.
Good morning. Excuse me, Cammie Corbett with the law firm of Hill, Ward, and Henderson. Were we sworn?
We haven't gotten there yet.
Okay. I'm here requesting on behalf of the applicant a continuance to the March 21 land use hearing. We received the staff report, and in reviewing it, we still have some questions, and we'd like an opportunity to further discuss those staff report with staff.
Okay. Is there anyone here that would like to speak just to the continuance of item J1, special use AB 22-0240? Anyone in the audience or online that wanted to speak to just the continuance? All right, seeing no one, then we'll continue special use AB 22-0240 to the March 21st, 2022 Land Use Hearing Officer hearing.
Okay, I have a number of published withdrawals and continuance, which I will now read. Item A1, variance application 21-0914. The applicant is Ronald Fair. This application is being continued to the February 21st, 2022 Land Use Hearing Officer meeting. Item A2, variance application 21-1248. The applicant is Maria del Rosario Perez and Guillermo del Rio. This application is being continued by staff to the February 21st, 2022 Land Use Hearing Officer meeting. Item A3, variance application 22-0009. The applicant is Annie Mintz Simmons. This application is out of order to be heard and is being continued to the February 21st, 2022 Land Use Hearing Officer meeting. Item A4, special use application AB 22-0027. The applicant is Mocha Asian Cuisine Incorporated. This application is being continued by staff to the February 21st, 2022 Land Use Hearing Officer meeting. Item A5, special use application 22-0063. The applicant is SRJ Restaurants Incorporated. This application is being continued by staff to the February 21st, 2022 Land Use Hearing Officer meeting. Item A6, variance application 22-0079. The applicant is John Saldana. This application is being continued by staff to the February 21st, 2022 Land Use Hearing Officer meeting. Item A7, variance application 22-0092. The applicant is Michael Brooks. This application is out of order to be heard and is being continued to the February 21st, 2022 Land Use Hearing Officer meeting. Item A8, variance application 22-0108. The applicant is Daniel Zimmerman. This application is out of order to be heard and is being continued to the February 21st, 2022 Land Use Hearing Officer meeting. Item A9, variance application 22-0132. The applicant is Mark Brenchley. This application is out of order to be heard and is being continued to the February 21st, 2022 Land Use Hearing Officer meeting. Item A10, Variance Application 22-0161. The applicant is Michael Kretzinger. This application is out of order to be heard and is being continued to the February 21st, 2022 Land Use Hearing Officer meeting. Item A11, Variance Application 22-0184. The applicant is Hindu Temple of Florida. This application is out of order to be heard and is being continued to the February 21st, 2022 Land Use Hearing Officer meeting. Item A12, Variance Application 22-0233. The applicant is William Rose. This application has been withdrawn by the petitioner. Item A13, Variance Application 22-0239. The applicant is Alvaro Rodriguez. This application is being continued by staff to the February 21st, 2022 Land Use Hearing Officer meeting. And finally, item A14, Variance Application 22-0258. The applicant is Laura Beth Kendrick. This application is being continued by the applicant to the February 21st, 2022 Land Use Hearing Officer meeting.
All right, thank you so much. I appreciate it. Let me start by going over our hearing procedures for today's agenda. Our hearing today consists of agenda items that require a public hearing by a land use hearing officer. I'll conduct the hearing on each agenda item and we'll file a decision within 15 working days, with the exception of the fee waiver and the appeal on today's agenda, 15 working days for the variance items after the conclusion of today's hearing. Our hearing today is informal. I'll ask questions related to the scope of direct testimony. I may call and question witnesses as I deem appropriate, and will decide all questions on procedure. I'll take evidence, but will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form, and all testimony must be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding by me unless it would be admissible over objections in a civil action. Our order of presentation today is as follows. For variances, the Development Services staff person assigned to the case presents the staff report and findings for 5 minutes. They have 5 minutes to do that. We'll then go to the applicant. The applicant has 15 minutes to make their presentation regarding their variance case. Next would be proponents. Anyone who would like to speak in favor of an agenda item, 15 minutes total for all opponents. The same is true for opponents. That's who's next. Anyone who would like to speak against an application also has 15 minutes total time. We then go back to Development Services to ask if they would like to amend their findings or clarification or provide additional comments. That is 5 minutes. And then finally, we go back to the applicant who has the last word on rebuttal for a total of 5 minutes. If you are going to speak, and when you come up to the microphone, if you're here in the room or if you are participating virtually, if you could start by giving us your name and address for the record. We are recording this hearing and we want to make sure that we have who is speaking and to what agenda item consistent. The same, if you are in the room and you complete your testimony at the podium, if you could see Joe, he's to my right with the Board of County Commissioners Records Office, and sign in also with your name, address, and the number of the agenda item you are speaking to. Let me now turn to the county attorney who will provide the legal requirements for appealing a decision made by a land use hearing officer.
Thank you, Ms. Finch. Good morning, everyone. My name is Cameron Clark. I'm an assistant county attorney. This land use hearing officer public hearing is for a variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed a case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record made at this public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing decision, by county staff, and by any interveners, each of whom may be represented by legal counsel. The following shall stand to appeal a decision of the hearing officer or to intervene in an appeal. First is the applicant. Second is anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the appeals board that was not presented to the hearing officer at today's hearing. The county attorney will recommend that the appeals board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence that is presented to the appeals board that is outside the record created at today's hearing could jeopardize the legality of the appeals board decision, and the presenter of that evidence could hurt his or her own cause. The safest course of action then is to write down any comments that you make today and to repeat those comments to the appeals board. Thank you.
Thank you, Mr. Clark. I appreciate it. All right, as I mentioned, all testimony must be under oath. So if you plan to speak today, if you could please stand and raise your right hand, and I'll swear you in. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? So help you God. Thank you. Please be seated. All right, Mr. Hisney, we're ready for the first case.
Okay, we have no vested rights on today's agenda, so that takes us to Section C, fee waivers, and we have one case. That's fee waiver 22-0302. The applicant is Richard Gozman. Pursuant to Section 9.7.d of the Development Review Procedures Manual, the applicant requests consideration of an exception by the land use hearing officer for a fee waiver application that cannot be approved by the administrator. The land use hearing officer shall conduct an independent review of the request based on the fee waiver criteria found in the DRPM and the testimony at today's hearing. In granting an exception, the LUHO shall be required to find extraordinary financial circumstances, emergency, catastrophe, or staff error which are outside the scope of the administrator's authority to consider. The applicant for the such subject fee waiver request is making a claim of staff error related to the processing of PRS 21-0048, which resulted in the need for the filing of a new PRS application. It is the fee that was paid for the new PRS application for which the applicant seeks the fee waiver. Following the applicant's presentation, staff findings will be presented by Brian Grady of Development Services.
All right. Good morning.
Hey, good morning, Madam Finch. Thank you for having us this morning. My name is Chris McNeil with McNeil Engineering, 15957 North Florida Avenue, on behalf of the applicant. As Mr. Hisney correctly referenced, this is we had to go through a second PRS for one that was initially requested. 21048 was the initial. And as part of that, I'd like to show an exhibit from the Elmo here if I can.
Okay.
Mr. McNeil, this presentation, is it already in optics, or will you have a paper copy or a digital copy to leave with the clerk?
I have both. Probably digital would be best if I can leave that copy.
Yes, you can.
Yeah, just for this case and all cases on today's agenda, we don't accept presentations on tablets or phones because those cannot be submitted into the record. But if you have a paper copy that you'd like, that's an exact copy of your presentation, you can preferably use that or submit it into the record.
Okay.
But we cannot take presentation materials on a tablet or a phone alone.
Okay, no problem.
So you do have this to submit?
I do have it, but I made one change to a typo that I had, ironically enough, that I can strike through and.
Okay,
and
yeah, if you can strike through it and then submit it into the record when you're finished.
Madam Hearing Officer, Mr. It can also be submitted digitally via a thumb drive or a disk, something that has an exact representation of what's being shown. So
Okay.
it can be a paper copy or it can be electronically through a thumb drive. If there's a typo like you described, it would also be helpful to just identify into the record what's going to be corrected and what's submitted.
As you get to that slide.
Okay.
Yeah.
Yep.
All right, please proceed. Thank you.
All right. Thank you. So this is a copy of the site plan that was in reference and that was submitted. The area that we were modifying at the time is in the far northwest corner of the site. The modification was to include an auxiliary or ancillary building up in the northwest corner, just a small ancillary building. As part of that request, I'd like to start kind of at the end and work my way back and so that I think that might be the best way to explain what happened. The building that's shown is shown at 7 feet from the west property line, which required a PD variation. The condition ultimately got written up and posted in the optics on February 22nd of 21, and it shows that the buffer would be 9 feet 9 inches as in lieu of 7, as a 3-inch reduction versus a 3-foot reduction. So that was the condition that made it approved. The issue there was that the staff report wasn't provided to us, and I'm going to circle back to this. It wasn't provided to us as part of but it is posted in optics, and I'll circle back to that just as a point of reference. During the process, and this is earlier now, backing up to middle of December, there was a conversation with a staff representative of mine and the case planner, and during that, they discussed the actual variance that would be required, the PD variation as part of the project, and what it would entail, and also how to submit it. The very next day, a variance request form was filled out and submitted into the record. It shows 3 feet, requesting for this building that we're talking about for this 20 feet of that structure. Also with that, it was requested we file a project narrative, a revised project narrative to document that as well, which we did. This is zoomed in on that northwest corner of the site, so you can see on the building, and there is no setback labeled on the building itself on the plan, but the line is shown there of where that setback would be, the dash line. What had happened is that the interpretation of this tree label, there's 3 trees that are labeled there right against this: a palm tree, 12-inch, oak tree, 25-inch, and another tree at a double trunk 9-inch tree. That was interpreted by the case planner, I believe, to be the setback, and that's where that came from. So with that, what we do know is that end result, of course, we had to go back for another case to get to 7 feet. But in regards to the exchange, what we're asking for is for staff to accept that responsibility for that half. We have, on behalf of the client, haven't charged them anything for the revised PRS ourselves, and nor will we, including the application fee for the revised PRS. So we felt like that at the point of when we got to the hearing, we knew we didn't have the staff report, but yet we should have asked for it and reviewed the condition, and that's on us. The other side of that is obviously the PD variation and the revised project narrative was provided. And so it just seems to be an unfortunate circumstance that we're hoping to share responsibility. And I think that concludes the presentation.
Right. Yeah, I read the backup and I saw where you submitted the revision on December 23rd of 2020 and requested that 3-foot reduction. So I don't have any questions at this time.
Thank you.
Thank you so much. If you could please sign in. Oh, did you note the typographical error?
Oh, let me show you that.
So the record is clear.
This is the printout version of what I have for the staff report, which down at the bottom of the date says 12/22/20, and it should actually say, I believe it's (2/22/21).
Oh, 21. Okay.
2/22/21.
All right. Thank you so much.
Yes, ma'am.
Appreciate it. All right. Mr. Hisney, you said that staff was going to make a presentation.
Yes, Brian Grady.
All right. Mr. Grady, good morning.
Good morning. For the record, Brian Grady, Hillsborough County Development Services. Again, In response to the presentation by the applicant, the staff is not not disputing the facts as outlined by the applicant regarding the request and what was requested and what occurred with respect to the filing of the staff report and the genesis of the condition stating 9.9 inches. I don't have anything further unless you have questions.
Yeah, no questions. Thank you. Mr. McNeil, if you could please sign in and submit your document into the record. All right. Thank you, Mr. Grady. I appreciate it. All right. With fee waivers, we don't take comment in support or in opposition. So, Mr. Hisney, any last word before we move on?
No, ma'am.
All right, Mr. McNeil, anything else from you before we close? Okay, thank you so much. Then with that, we'll close fee waiver 22-0302 and go to the next case.
Okay. We have no remands today, no reconsideration requests, and no site development variances, which then takes us to section G of our agenda, sign variances. And we have one case, and that is application number 22-0234. The applicant is Steve Phillips, requesting a sign variance. Staff findings will be presented by Kim King.
All right. Good morning, Ms. King.
Good morning. This variance request, the applicant is requesting variances to the Keystone Odessa Rural Development Standards for an existing monument sign serving a church that is located in the rural area of the Keystone Odessa Community Plan. Per LDC Section 30806C2 of the Keystone Odessa Rural Development Standards, all monument signs shall be externally illuminated only. Additionally, per LDC Section 30606C3, the use of plastic display panels on all ground signs is prohibited. The applicant is requesting variances to allow a plastic display panel with internal illumination on the top portion of the sign and a changeable copy panel with internal illumination on the bottom portion of the sign. In the findings, we have a sign permit was issued in error on July 29th, 2020 to replace the existing sign on the property, and the property is under code citation for the sign. And that concludes my presentation.
Ms. King, before you leave, let me just ask you a couple quick questions. So the permit was issued in error and the sign was built. Is the sign built according to the permit that was issued? And I understand there's an issue with the Keystone Rural Standards, but the sign code, does the sign meet the sign code?
Yes, as far as the size, height, and setback, the sign is in compliance with that.
And it was built in accordance with the permit that was issued. Is that correct?
Yes.
Okay,
Yes.
Understood. All right, thank you so much. Is the applicant here? Good morning. Good morning. If you could give us your name and address, please.
Yes, my name is Steve Phillips. I am a church volunteer and a member of the vestry at Church of the Resurrection, which is the church in question. We're at 7509 Van Dyke Road, Odessa, Florida, 33556. And I would like to thank everybody for being here, Ms. Finch, and all the DSD employees. I've worked with Ms. King and others on the phone. It's been very helpful, and thank you. I also would like to introduce some others that are going to speak, later in support. Bishop Kevin Donlin in the back. He's our rector at the church, and Father David Brookman, who is also in the church leadership, so we're all here. And what we're applying for a variance, has already been said, variance 22-0234 relating to permit NSG 22917, which as Ms. King said, was issued by Hillsborough County DSD on 7/22 of 2020. I'd like to start with just a synopsis of the events that brought us here, and then I think Father Bishop Kevin will get up and say a few words also. But what happened was we bought this property. We established a church there, and the church leadership decided that the Church of the Resurrection needed a digital sign so that we could communicate with the local community concerning inspirational measures, county community events and emergency type instructions, that kind of thing. So we felt like it was beneficial for us and for the community. We would send out a request for proposals and selected Robson Corporation based on their experience and reputation and their design and price, of course. Robson designed the sign and applied for a permit to Hillsborough County, which was approved on 7/22/2020. And after construction was completed, Robson installed the sign on 10/30/2020, and it was, of course, approved by Hillsborough County. The church has successfully used the sign since, which is over a year, really close to a year and a half, I believe. Then the church received a notice of violation on 3/4/2021, stating that the duly permitted sign was in violation of this section 3.08.06.c.2 and 3 of the Keystone Odessa Rural Development Standards in the LDC. So there's not a lot to say there. It's just that, from our perspective, we followed all the rules. We proceeded in good faith. Due diligence was done, and we have our permit, built the sign. It's been in use, and it's been extremely beneficial, I believe, for the church and for the local community. I do have one thing. We drove through. My wife and I drove through the area and found, I believe, 5 different instances of digital signs in the Keystone area. So I don't really, understand that. And we found one, what'd you call it? Plastic illuminated display. So I brought, and I can leave those with you. We have a map of the area with each of those instances highlighted and numbered, and then pictures behind it that are numbered, so for easy. And I'd like to submit that if possible. So that, just, to recap, there's hardly any need, but we hired the most respectful sign company. They designed it and applied for a permit. Hillsborough approved the permit, and we proceeded in good faith. They installed it. We've been using it since. And after a year and a half, I guess maybe somebody complained, and here we are with the violation. So that is what I wanted to present. And I believe Bishop Kevin is just going to come up and say a few words about.
Okay, thank you so much. If you could please sign in and you could submit your documents and pictures into the record. Thank you so much. Good morning.
Morning, Kevin Donlin, the rector and pastor at Resurrection. Thanks for taking your time, Ms. King. Thanks for your effectiveness again. I think Mr. Phillips kind of covered the events as to kind of brought us here. So make a couple observations real quick, and I want to take up your time more than we have to. Of course, people like me who are rectors of parishes, and we believe our church is supposed to be good members of the community, we're always puzzled when we find out that we're told we're not when we thought we were. So that's caused some dis-ease in the parish community. It makes us look bad in leadership when we, as Steve pointed out, we did follow all the norms. So we're not trying to blame anybody, but the fallout on us has probably been greater than somebody who complained about the sign. So I just want to point out that. Secondly, the sign itself has been a benefit to the Keystone community. It's not just church events that get put on there. That's self-promotion. That would not serve anybody. The reality is that when the storms have occurred and we've been able to open the parish hall for a safe place to be in the storms, we're able to get that up on the sign with alacrity. If we had another sign that we had to post something on, we wouldn't be able to do it with efficiency. So for safety purposes for the community, for the few people around the Keystone area, many of the workers, for example, who commute through there, that sign has been a safe haven that if there's a need both for safety during a storm, that Resurrection's available. It's also been a place that people in the community, especially during the COVID epidemic, needed foodstuffs. we have a Wednesday food pantry that we make available to people. Again, that information is put up immediately on the sign, and then we can take it down. It would be far more of an eyesore if we had to take down and put up individual signs on our lawn every week that some special event was going on. It's not practical, and nor is it particularly becoming. And I think most of the people in Keystone would see that. I do have to mention an irony to the board. The Keystone group that's brought this complaint called last week to use Church of the Resurrection as a meeting place. So I'm utterly puzzled by this on so many levels, but it's human nature, and we'll chuckle about it. Lastly, the sign is not an inexpensive proposition. Granted, it was the gift of a benefactor to the tune of almost $30,000. We don't have that kind of resources to take down and put something else up. So the level of inconvenience this would cause, and to us as a community, is not insignificant. I don't know all the complexities of all the law. I mean, I am a church lawyer by training, but here's a little bit that I do know. I've read the statutes on the light issues. What I'm told by experts is the LED panels provide exterior illumination and not internal illumination. So those are experts, I'm not. So I need somebody to clarify why one group of experts understands it's internal illumination and there's a variance that's requests because they think it's external illumination. So that's just a clarification that I don't have. But if in your decisions, if there is a decision that's adverse to us, that's going to need to be explained because it's unclear. So I think those are the major things. We want to be a service to the community. That sign helps us do that. I think it's a benefit to Keystone. Obviously, Keystone thinks that. They wanted to meet at the church while their meeting place, which is the park and the library right on Gun Highway, is being renovated. We're happy to accommodate them. I think they would probably want to use the sign to announce that's where they're meeting. Wouldn't that be ironic? But we're willing to negotiate if there needs to be changes within reason. We're not saying this is the way it has to be hard and fast, but obviously the amount of investment we've made limits the amount of change we can make. I hope that clarifies any questions.
I don't have any questions at this
Okay,
time.
thank you for
Thank
your
you so
time.
much. If you could please sign.
I
in
can.
the
Thanks for your time.
corrections. Thank you. Does that complete the presentation from the applicant? Is there anyone else that wanted to speak as part of the applicant's team? Okay. Then we will go to anyone that would like to speak in support. Is there anyone in favor of this application? No one online? No one in the room? Anyone in opposition to the request? No one. No one in the room. All right, county staff. Ms. King, anything further you'd like to add?
Nothing further.
All right, and then the applicant has the last word. If you'd like to say anything further, sir, anything? Oh. If you just give us your name and name real quick for the
Sure.
record.
Steve Phillips again
Thank
with
you.
Church of the Resurrection. I appreciate everybody's time and thanks for listening to us. We look forward to whatever decision is made. And, the other thing I did want to say, if I have just a second, is that the top portion of that sign is internally illuminated. There's no, so if that would help any, we could work with the county maybe and work with Robson to modify that portion of the sign.
Let me ask you one question that I neglected to ask in the beginning, and that is, have you talked to your neighbors? Have you heard from anybody about this?
We haven't
The
heard from,
vicinity?
we've talked to neighbors, not specifically about this. I sent all the letters out and I didn't get anything in
You
reply.
haven't heard anything back?
Nothing, no, not a call or anything.
Okay.
So that's it.
All right, thank you again. I appreciate
Thank you
it.
very much.
Then with that, we'll close variance 22-0234 and go to the next case.
That concludes the sign variances, which then takes us to section H of the agenda, the general variances. First case is item H1, application 22-0065. The applicant is Donald and Paula Riley. They are requesting a variance to lot development standards. Staff findings will be presented by Sam Ball.
All right, good morning.
Good morning, Sam Ball, Development Services. The applicant is requesting a setback variance in order to accommodate a proposed covered patio for a single-family residence on a property zoned PD 89-0097. According to LDC Section 60103I4, covered patios, as defined in Article 12, may intrude no more than 13 feet into the required rear yard and shall not intrude into the required side or front yards, except in circumstances that do not apply in this case. In no case shall the permitted intrusion of the covered patio reduce the yard provided to less than 10 feet. Condition 6 of PD 89-0097 requires a minimum rear setback of 15 feet on the subject property. The resulting minimum required setback for the proposed covered patio is 10 feet. The applicant requests a 5-foot reduction to the required rear setback to allow a 5-foot rear setback. The proposed covered patio will replace an existing screen enclosed patio with a screen roof. The proposed covered patio will abut a private drainage utilities easement that is owned by the neighborhood homeowners association. The site plan submitted by the applicant shows the patio roof will project 12 inches into the easement airspace. The applicant submitted a letter of no objection from the neighborhood HOA, which has been placed into the record. That concludes my report. Thank you.
Thank you. I appreciate it. Is the applicant here? Good morning, sir. Start by giving us your name and address, please.
Just down where I can see.
Please.
Don Riley and my wife Paula is behind me here at 4921 Grand Banks Drive, Waimama, 33598.
Thank you.
Thank you very much for allowing us this time. I provided here a packet for yourself and for the record.
Okay. You could submit that into the record when you're done or at this time if you'd like.
It doesn't matter.
All right.
It's
You can do
okay.
it when you're finished. Thank you.
Okay. Now, I want to thank Sam and Carmen for their assistance and guidance through this process that has been kind of lengthy for us, and we had to go for a continuance for getting some other minor issues resolved, or we'd have been here last month. But anyway, this variance request is seeking approval to the requirements of the Hillsborough County Land Development Code 6.01.03.I.4. Solid roof screen room shall not reduce the rear yard area to less than 10 feet. And I think Sam outlined that in it. I'd like to point out our property is located in Valencia Lakes, a senior gated community near Sun City Center. Our lot backs up to a lake, and our existing structure with the screened lanai were constructed by the developer GL Homes in 2018. I'd like to point out we are not the original owners of the lot. The original owner never resided there and only owned it for about 3 months. We purchased the home in October 2018 with everything in place there. We propose to modify the existing screened lanai gable roof with a solid flat roof in there. Now, the advantages to this modification are we're going to reduce the direct sun on the lanai, thereby reducing risk of cancer from excessive sun exposure for us in the senior environments that can get exposed to melanoma, et cetera. This will greatly reduce rain onto the lanai now, which the screened area represents probably 60 to 65% of the whole back lanai portion to the house. This is also going to eliminate direct bird droppings, which these large birds sit on top of these screened lanais and like to always give you a gift on their departure. This is going to increase the lanai usability by having the roof over the whole, what's now the screened area, so we can move freely within the area. Now, I'd like to point out that the rear yard area is what it is, and it's not going to change by this. And this is going to add home value and is more aesthetically pleasing. Now, do you have a projection here?
Yes, sir.
I do have 2 pictures that are included in the packet for you. But,
Yeah, you can put them there. And then if you just turn on that microphone that's right there by pressing the button, you'll see it light up red. It looks the button with a person on it.
oh, that one,
There
okay.
you go. Thank you. Go ahead.
High technology.
Oh, and your picture. There you go. Perfect.
Okay. What I'd like to draw your attention to, this is what I'll refer to as picture number 1. This really depicts the screened area as it is today, and you'll see the lake portion is off to the right. And that happens to be the east side of the home structure. So that's the way it's been since 2018, constructed by GL Homes. Now, what I'd like to do here is also show you in this, what I'll define as picture number 2, which has some measurements on it. This further reflects the dimensions which are currently in place, and with the replacement or modification of the screen roof, it's not going to change. It is what it is. And yeah. These photos show that the rear yard area to the lake is 20 feet 6 inches. While our property line on the lakeside is short of the actual lake boundary, it remains homeowners' responsibility for all the maintenance that exists there. That's pretty common within homeowners associations. Now, as Sam mentioned, the Property Owners Association has provided a letter of non-objection to our activities. And we also have several letters of support from residents that are within the 300-foot notification area. Nobody outside of the 300-foot notice, all urging board approval, and they're included in here for your review. The existing home structure on the lanai side of the walls on here, as we'll go back to this picture, remain unchanged. So everything that was put in place by the developer on the footprint of the home structure and the lanai will not change. We're only changing the roof. In summary, we're requesting your approval as a variance to the Land Development Code as being reasonable and a property improvement. Letters from some of the residents, which I mentioned in the POA, urging your approval are included. This modification does not change any existing usability of the rear yard area to us, the adjoining residents, or the Property Owners Association. This variance request enhances the usability of the lanai and is aesthetically pleasing. This concludes my input.
I just have a quick question just to make sure it's clear for the record. So the proposed solid roof structure, the sides continue to be screened in, correct?
Oh, yes, the north, the south, and the lakeside remain screened as they see them today. It's only the roof structure taking that peaked roof down, which is about 13 foot 6 inches to 10.
And so but the sides, the footprint of the actual patio, that doesn't change in size.
Does not change.
You're essentially only changing a screened roof to a solid roof. Is that correct? I
Correct,
understand.
absolutely.
All right. Thank you so much. If you'd like to sign in, and then you can submit your documents and pictures.
Okay, thank you very much.
Thank you for your
Appreciate it.
time and testimony. I appreciate it. All right. We will ask for anyone that would like to speak in support. Is there anyone in favor in the room or online? Okay, no one. Anyone in opposition to this request? No one online, no one in the room. Okay, we'll go back to Mr. Hisney and ask if he has any other comments before we move on.
No, ma'am.
All right, and then, sir, you have the last word if you'd like it. You don't need to take it, but you have the last word as the applicant if you'd like to take it, but you don't have to. All right. Thank you so much. I appreciate your time. All right, with that, we'll close variance 22-0065 and go to the next case.
And our next case is item H2, variance application 22-0146. The applicant is Damian Alexander. Request is a variance to fence requirement. Staff findings will be presented by Sam Ball.
Good morning.
Good morning again. Sam Ball with Development Services. The applicant is requesting a height variance in order to allow an existing fence to remain on an ASC 1 zoned property. According to section 6, 7, 672C1A and 672C2. Fences over 4 feet in height shall not be allowed within required front yards that function as a front yard, except under specific conditions that do not apply to this case. The applicant requests a 2-foot increase to the maximum height permitted to allow a 6-foot high fence to remain within the required 50-foot front yard along the south side of the subject property on Lowell Road. The applicant has advised staff that they operate a home-based dog training business on the property. This activity is a permissible use of the property subject to the home-based business requirements and LDC section 61148 and the kennel requirement found in LDC section 61152. The applicant has been cited by code enforcement for the fence, and that concludes my report. Thank you.
All right, thank you so much. Is the applicant here? I understand. Yes, sir. Good morning.
Hello, Senior Airman Damien Alexander, United States Air Force retired.
Danny Leal Alexander, his wife, at 5207 Lowell Road, Tampa, Florida.
Thank you so much.
5207 Lowell Road, Tampa, Florida, 33624.
Thank you, sir.
Good morning. We are requesting a fence height for variance for 5207 Lowell. We purchased our home in 2017 and began a multi-phase, multi-year renovation project. This home also serves as our family dog training and rehabilitation business. 5207 Lowell Road is an ASC1 agricultural single family where the front yard serves as the property's backyard. When installing the fence in 2019, we completed the following due diligence. We surveyed the neighborhood and found what was customary for the area. We consulted architects and fence vendors.
Is there a way to show?
There, I see it.
Thank you. Appreciate that. We take a survey of the area and then went back to the fence and wall regulations at the Municipal Code Library online and found that the general purpose was for conservation and protection of the property, safety, security, and enhancement, and improvement of visual environment, neat appearance in keeping with the neighborhood character. We also found that construction can be in a workmanlike manner and shall be of sound and sturdy construction. We also found as part of C.1, point F and H, that the maximum average height may be 6 feet, except as described or as exceptions allow. And we did also find that walls up to 8 feet in height may be erected in yards which abut arterial streets and collector streets as defined under the Hillsborough County Functional Classification System. We looked at the neighborhood and found that that was in keeping with the lot and then prioritized because 5207 Lowell abuts to a collector road. The fence is constructed in that workmanlike professional manner, especially looking at the homes that were of higher value or renovated, which we were aspiring our home to be. We then made the construction workmanlike and professional with local licensed vendors, improving the visual environment and in keeping with the neighborhood character. The fence is located at the furthest recess because we also wanted a symmetrical, continuous line, protecting the mature trees and their root systems. These mature trees we found were also part of the environment and the home and the character of the area.
Granting this variance request to keep the fence as is will allow us to complete our in-progress renovations and expansions plan that include a 3-car garage, extended patio and paved driveway, and formalized training area for family dog and rehabilitation business. It will also help us avoid a hardship, the loss of our initial investment, reconstruction costs, and the cost of removal of mature trees. This cost, we've done analysis, is in excess of $30,000. Also, it's the loss of future revenue. A smaller training area would negatively impact our business, and an inability to continue our planned renovation would negatively impact our property potential value. In conclusion, granting this variance will support the financial growth potential of our property, support our family business, and property values in the area in the long run.
We are submitting a packet with that includes the information presented today, links to our resources, as well as the compliant to the regulations in support visually labeled exhibits A through G. Thank you so much for your time.
Thank you. I just have a quick question. You answered my question about if there are fences, other 6-foot high fences in the area. Your graphic shows that. Did you talk to your neighbors about this variance request?
We did, and we sent out the
We
notification.
sent out all the notifications. We sent everything. We had an email address for them to respond. We've received no notifications or displeasure.
All right. And do you know how this came about to code enforcement?
Someone called from about over a quarter mile away, actually further than that, and said he was upset because he couldn't see into our yard.
And was afraid that illegal activity may have been going on and that someone should check out.
We find that it may be differently motivated.
Oh,
Yeah.
understood. And so you're running a dog training business, which the county has, the staff person is verified, complies with the zoning and is permitted. And so what is the reason? Because the variance, the increase in height, you could put a 4-foot high fence there in that same location. What is the reason for the increase of 2 feet relative to your business?
My husband's the main dog trainer, so I'll let him answer.
Thank you
There's
so
several
much.
things. One, from a distraction standpoint, having a 4-foot high fence allows no distance from people. Also, the dogs will see it's constant distraction. Safety reasons. I train larger dogs for rehabilitation. Those dogs have the ability to jump over a 4-foot fence. Safety and security, leaving the dogs in the yard. That doesn't allow me to walk away for 5 seconds to go in the house because now the dog is unsupervised. Someone can come in and steal the dog. And just safety overall, just for our home, for our own personal protection.
All right. Thank you. That's answered my questions.
Yes,
Thank
ma'am.
you. If you can sign in and submit your documents into the
Yes,
record.
ma'am. Thank
And
you.
thank you to the committee.
Thank you so much. Appreciate your time. All right. We'll ask for anyone that would like to speak in support. Anyone in favor in the room or online? Seeing no one?
I have a Miguel online.
You're
sign up for
speaking in support or in opposition?
He was part of the applicant's team.
Oh. What's the gentleman's name?
Miguel Agar.
Stan is our guy.
Maybe someone signed up in error.
Maybe.
All right. So, but no one else to speak on your behalf. Okay. All right. All right. So just to be clear, is there anyone that would like to speak in support of this application? Seeing no one, anyone in opposition to the request? All right. No one in the room. County staff, anything further before we close?
No, ma'am, nothing further.
All right. And sir, ma'am, do you have anything else before we close the application? Thank you. I appreciate it. We'll close variance 22-0146 and go to the next case.
That takes us to our final variance, item H3, application 22-0236. The applicant is Belvedere Builders, and they are requesting a variance to accessory structure requirements. Staff findings will be presented by Kevin DeFrank.
Good morning.
Good morning, everyone. Kevin DeFrank with Development Services. For this variance case, the applicant is requesting setback and height variances for a proposed detached garage on a single-family lot zone AS1. In reference to the setback variance request, per the Land Development Code, accessory structures shall not be erected in any required front yard except under certain circumstances, which do not apply to this case. An accessory structure shall be permitted in front yards at twice the depth of the required front yard, or 50 feet, whichever is less. And additionally, such structure shall not occupy required side yards. And per the Land Development Code, the minimum required front yard setback in the AS1 district is 50 feet. Therefore, the minimum required front setback for the proposed detached garage is 50 feet. However, the applicant requests a 45-foot reduction to the required front yard setback to allow a setback of 5 feet from the northwesterly line. Now, in reference to the height variance request, per the Land Development Code, accessory structures shall not exceed 15 feet in height, except where the accessory structures meets the primary structure setback of the district, in which case the maximum height of the accessory structure may be that of the district. As proposed, the subject garage will not meet the required front yard of the AS1 district, and therefore is limited to the maximum height of 15 feet. And specifically, the applicant requests a 7-foot, 8-inch increase to the permitted structure height to allow a height of 22 feet and 8 inches. And staff findings include that the AS1 district requires a minimum lot size of 1 acre and a minimum lot width of 150 feet. And the subject parcel property is 0.94 acres in size and 125 feet in width. However, it has been certified as a legal non-conforming lot per NCL 21-1346, which is in the case record. Also, access to the subject property is provided via an easement, Collins Springs Cove, which connects to a public street, Watson Road, to the north of the property. And per the Land Development Code, required yards on lots accessed by easements shall be oriented with respect to the roadway, which the easement connects as if the lot abutted the roadway. And therefore, the required front yard on the subject property is along the northwesterly lot line. Now, variance 21-1211 was approved for the subject detached garage last year to allow a front setback of 5 feet. And at that time, the applicant stated that the garage would have a maximum height of 15 feet. However, the applicant has since revised the site plan for the garage, which now has a proposed height of 22 feet and 8 inches, and therefore requires approval of a new variance. And last but not least, according to the applicant, there are plans to replace the existing house on the property with the new house shown on the survey submitted with the subject variance. However, the applicant has advised staff that the new house is not part of the subject variance request, and therefore staff has advised the applicant that any variances which may be identified and requested in the future for the new house will require submittal of a new variance application at that time. And that concludes my report, and I'm available for any questions. Thank you.
No questions at this time. Thank you so much. Is the applicant here? Good morning. I'm not sure that microphone is on. You'll see a button with a person on it. There you go.
There we go. Mike Kildow, Belvedere Builders, address 1385 Oakfield Drive, Brandon, Florida, 33511. The staff member is correct. We'd like to obtain permission for the new detached garage to have a roof height of 22 feet, 8 inches. The current land development code, AS1, allows for a height of 15 feet, but we would like the variance to obtain the approval to build the garage to a height of 22 feet, 8 inches. I believe we emailed this to you, but I'd like to submit this showing the proposed garage design. So, and then, so this is the proposed garage design. And then we want that to match the proposed house design. So very similar in design. We feel like if we did anything else, it would, they wouldn't, of course, it wouldn't match and just wouldn't look right. So I have Mr. Simon Spears here, who is the landowner, the current client, and he may have a couple of things to say.
All right. Thank you so much. If you could please sign in. Morning, sir.
Good morning. Simon Spears, 6713 Collins Spring Cove, Riverview, Florida, 33578. Thank you for hearing us. Unfortunately, we were here not too long ago and we overlooked a crucial point, which was the roof height. And what I'd like to do is to show you why we overlooked the roof height. If I may. That's a survey of the entire property.
Sir, if you could turn that microphone on that's right in front of you. There you go. Perfect. Go ahead.
This is a survey of the entire property. This section down here is the riverbank. This is a raise of about 28 feet from this point to this point. This is the proposed garage with the 5-foot setback. I don't know if you can see this. I have a larger example of it somewhere. I think.
Sir, while you're looking, let me just ask you a question. I recall this application from the prior application where the 5-foot variance was approved. And it's my recollection that there's a significant elevation issue.
From this elevation just here to this elevation just here is about 7.5 feet difference. It rises 7.5 feet towards the north. The north property is, I'm not exactly sure who owns it, but I know Mosaic manage it. It will not be built on. There is nobody going to live there. It's a couple of 100 acres from what I believe. But there is no visual distractions from anybody who might build there. It isn't going to be an obstacle in the way of a view. The access road through here is only for my one neighbor on the east side. I think it's the east, yes. He has no objections to it. Behind the garage structure itself, along the property line, will be built a retaining wall. Is that the right way up? No.
There you go.
So it's going to be a retaining wall which will be 5 feet back from the house and go around 3 sides of the structure. It'll start down here, go back all the way across. So the actual elevation from the rear, we are in compliance. From the front, we are not, and we overlook that matter. This is what it will look like when built. So the garage structure will have a 12-12 roof, the same as the house. I'm going to bring a little bit of South England to Riverview. This is going to be very, very similar with the shake roof, with the stone, with the brick accents. It is going to be an absolutely beautiful house if you guys let me build it. So that is the house being built. All this section down here is going to be a quite extensive retaining wall. This will be leveled and this will stay in a slope going back, but this slope continues all the way back up, levels off at the road and then goes back up again. So that's why we missed it, is we just didn't look close enough at the elevations. And as Mike says, it's going to be a 6-car garage because I collect cars. My wife's always mad at me because I collect cars, so I'm going to go and hide in that. But that's basically my presentation. That's the reasons why. It is because this is how I want the house to look. It isn't for any wonderful thing that's going to help the community. It's very personal. This is my epitaph. This is what I'm going to leave behind. That's the end of my presentation.
I understand the request. Thank you, sir. I appreciate it. If you could please sign in. All right. Is there anyone in the room or online that would like to speak in support of this application? Seeing no one, anyone in opposition to the request? No one. County staff, anything else?
No, nothing further.
All right. And the applicant has the last word if you'd like it. All right. Then with that, we'll close variance 22-0236 and go to the next case.
So that concludes section H of the agenda, which then takes us to section J, special uses. We had one case, special use 22-0240 scheduled for today. However, at the start of the hearing, that case was continued to March 21st, Lujo, which then takes us to section I of the agenda, appeals. We have one appeal, item I1. This is Appeal 22-0346. The applicant or appellant rather is Manatee Rv Ruskin LLC. The applicant is appealing the administrator's decision in zoning interpretation 21-1281.
All right. We will have, is there a staff presentation as a part of this request?
Yeah, our comments follow the applicant's presentation.
All right. So we'll start with the applicant. And if you could, I'd like to ask a question of you before you, while you're coming up. As you're probably aware, the Land Development Code provides for a 5-day decision from the land use hearing officer regarding appeals. What you may not be aware of is the court reporter that provides us the transcript. That does not come to us as the hearing officer until probably next Tuesday or Wednesday, which would be following the 5 days or perhaps on the same day. So what I'd like to do, if it's acceptable to you, is extend that period of time to Friday, February 4th for my decision to be filed, if that would be acceptable.
Absolutely.
Thank you. If you could please give us your name and address.
This is Jamie Mayer for the applicant, or the appellant rather, with the law firm of Hill Ward Henderson, 101 East Kennedy Boulevard, Suite 3700, Tampa. I have a PowerPoint if I might just load that before starting my presentation.
Absolutely.
Is there a clicker or do I just ask for next slide? Okay, perfect. All right. Oh, well, right. For it to be up on the screen. And you can just go ahead and go to the next slide, please. This is an appeal of a zoning interpretation of the zoning administrator related to property known as the Manatee Rv Park, which operates in accordance with an approved PD. The operations include long-term leases of many of the RV units, and many of the RV units also have accessory attachments such as carports, sheds, and patios. On the screen is the PD site plan, which shows the general location and layout of the park. It's very close to the Hillsborough-Manatee border off the Tamiami Trail. Next slide, please. In the applicant's zoning interpretation request, the zoning administrator was asked to confirm whether certain restrictions were contained in the PD, specifically whether there is a limitation on the duration of stays in the RV units and whether there is a prohibition on the construction of accessory attachments to the units. And the administrator confirmed that the PD does not contain these restrictions. That should have been the end of the analysis. But the zoning administrator erred when he went on to conclude that the long-term stays and accessory attachments are inconsistent with the definition of recreational vehicle in the code, specifically the word temporary in the definition. This finding requires you to ignore the rest of the code. There's nothing provided from the code or its history to show that this is what the word temporary means. In fact, as you'll see, the legislative history in fact indicates the contrary, that these limitations had to be added because they weren't previously there. Next slide, please. Now in a PD, the approved PD conditions always control. And in the RV Park PD, there's a condition that requires strict adherence to a code section that doesn't contain these restrictions. Specifically, that was the code in 1994 at the time of PD approval. It did not contain these restrictions. These restrictions were not added to the code until 2004, 10 years after the PD's approval. And the zoning administrator confirms this with an express finding that there is no prohibition or limitation on durations of stays in RV units or on construction of accessory attachments in either the terms of PD approval or the code at the time of approval. Despite this, he finds that the uses at issue are inconsistent with the definition of, with the word temporary in the definition of RV, and therefore not allowed in the PD. This is retroactively modifying the approved conditions of a PD. Next slide, please. So let's take a look at the definition of recreational vehicle. At the top is the Florida statutes section 320.01, which regulates motor vehicle licenses. And as you can see, the word temporary and the definition of recreational vehicle in this paragraph is very similar to the three definitions you see below, which are from the code versions at issue. Now, I did check the legislative history, and the Florida statute has remained unchanged since about 1976. In the zoning administrator's research, the broad definition of RV was added in 1988 when the 1976 zoning code was still in effect. Prior to that, individual types of RVs were defined, and they largely tracked the statute's language as well. And I will enter a copy of this statute into the record since that is permitted as a Florida statute. Next slide, please. So this definition of RV in both the code and the Florida statutes pertains to the type of vehicle. A recreational vehicle park, on the other hand, is a type of land use. And this land use type has always been regulated in its own code section, which you'll see has changed over time. But the vehicle type definition has remained the same, as you saw on the previous slide. The Florida statutes includes mobile homes, RVs, motorcycles, trucks. If it's a vehicle, it needs a license, whether it's stationary and being lived in, or whether it's on the road. So the definition of RV describes the form of vehicle, not the regulations that govern the use of an RV park. And the definition even says it's a vehicle type primarily for temporary living. This does not mean exclusively. And in fact, as you're about to see, the 1976 zoning code expressly contemplated, quote, long-term or permanent living in these types of vehicles. Next slide, please. So the 1976 zoning code included a standard zoning district, the Mobile Home Park and RV Park District, MHP RVP District, which is designed, as you can see in the excerpt below, to provide safe, healthful living for park residents, whether permanent, long-term, or transient. And as you saw, the 1976 code included the definition of RV, or included the word temporary in the definition of RV. Now at that time, the code was entirely silent as to these accessory attachments. Next slide, please. Now, of course, the code overhaul, and I think later in the 80s or the early 90s, produced the regulations that were in effect governing mobile homes and RV parks at the time of the PD's approval in 1994. At this time, the code was silent as to both durations of stay or additions of accessory attachments. And of course, as you saw, the definition of RV still included the word temporary. In 2004, the code section of the code had been entirely renumbered, but the substance of the statute, or I'm sorry, the substance of this section was pretty much the same framework. Both the 1994 and 2004 code address, in order of subsection, access, internal roadways, density, use of loudspeakers, storm shelters, and coastal high hazard area. Now, 2 additional subsections were added in 2004 that were not there in 1994. That is, addition or attachment of accessory structures and duration of stay for recreational vehicle parks. And the RV definition, of course, included the word temporary. Next slide, please. Now, specific to the RV park itself, it received original site plan approval in 1983, and that approval referenced the 1976 MHP RVP regulations. Subsequently, the approval was amended by PRS approval in 1994, resulting in the code or the site plan and conditions that govern the PD today. Again, there's a condition in that conditions of approval that states all development for the recreational vehicle park shall proceed in strict accordance with section 2.5.19.4. Again, that is the 1994 code section that was silent as to these limitations at issue that were not added until 2004. Now, it's important to note that the zoning administrator finds that 400 units are allowed in the PD because they were approved under the PD. But this unit count was approved under a bonus density provision in the 1994 version that has subsequently changed in the 2004 version that would not apply today. So the reason that these are still allowed is because the zoning administrator finds that the 1994 code, by way of that condition, is what governs the site plan. But this is the exact result that is, we're being told is not the case for these other 2 limitations. Next slide, please. So if the uses of long-term durations of stay and accessory attachments were always inconsistent with the word temporary, why would they have been expressly added to the code in 2004? And why would such specific limitations be contained implicitly in a single word in the definition section? And why would that implicit meaning actually contradict, for example, the 1976 code, which expressly contemplated long-term and permanent stays? A plain reading of the code and its history simply does not support this result. Next slide, please. There is no standalone definition of temporary in the code. The word does not in and of itself prescribe a duration of stay. I could be a temporary employee for years. I could temporarily lease my apartment for a year. I could set up a temporary mobile home somewhere for 6 months. Much of the code is like this. You'll have a type of use that is defined, and then the actual regulations governing the use is in its own section elsewhere in the code. Some examples include camps, temporary mobile home facilities, and disaster relief dwellings. All include the word temporary in their definition, but none of them prescribe a duration of stay in the definition. Each has its own specific regulatory section where limitations, operations, and durations are specified. Camps, for example, may only be occupied for 90 days. Temporary mobile home facilities may range from 1 to 2 years of stay, depending on the type. Disaster relief dwellings may be inhabited for 1 year. By contrast, the definition of hotel-motel in the code includes a specific duration in the definition, but the definition doesn't even use the word temporary. Next slide, please. So if temporary, the word, really prescribed a duration of stay, there would be no need to specify those durations in these regulatory sections. But also, there are such different durations of stay that for that reason alone, the word cannot have such a specific implicit meaning. This is why the zoning administrator has to rely on the subsequently enacted 2004 code section, which he finds doesn't apply to the PD, but uses it to illuminate that these limitations have always existed implicitly by way of this single word. This interpretation also defies basic principles of statutory interpretation that courts routinely use. It renders those regulatory sections superfluous by saying that the definition contains it all. It also requires a fluctuating meaning of the word temporary, because sometimes it means 90 days, sometimes 120, sometimes a year, sometimes 2, and also sometimes accessory attachments. Courts do not read regulations in ways that raise ambiguity where there isn't any. They don't read words and provisions in isolation of the entire act. And they presume consistency of meaning and usage throughout. Next slide, please. It is clear that the county wanted to regulate the durations of stay and accessory attachments in RV parks, but they had to add these limitations because they weren't previously there. Going forward, RV parks since 2004 can be regulated in this way if they are approved after that. But the county cannot impose these conditions and restrictions in a PD that predates them. Again, an approved PD is controlled by its conditions. It seems a pretty strong coincidence that the 2 provisions added in 2004, well after the PD's approval, are the 2 specific limitations that have supposedly always been in the word temporary. Again, the analysis should have ended at the 2004 code doesn't apply. The definition of RV pertains to vehicle type, not land use type. Our land use type is governed by our PD. Therefore, the owner respectfully requests relief from the zoning interpretation because imposing these new restrictions in a PD that doesn't contain them inordinately burdens and unreasonably limits the private property rights of the owner. Thank you.
Thank you so much. If you could please sign in. All right, county staff.
So in the applicant's written appeal, in the introductory section of paragraph 3, they state that the zoning administrator in his interpretation found that the RP park is subject to an approved PD site plan and condition, and found that the PD does not contain any limitation or duration of stays in RV units, nor in the addition of aftermarket attachments such as porches, carports, or sheds. This was the scope of the zoning interpretation request made by the applicant. The zoning administrator had erred when, despite his finding on the approved PD he exceeded the scope of the request and applied his interpretation of the definition of recreational vehicle as modifying the PD site plan and conditions of approval. I'd like to point out that in their request, the applicant actually asked 3 questions. First one was question of whether a maximum of 400 recreational RV units are permitted in the RV park. Second question was the only restrictions in the RV park are those contained in the PD conditions or approval of the 1994 LDC section 2.5.19.4. And 3, there is no prohibition or limitation in either PD or section 2.5.19.4 or the duration of stays in RV units or on the construction of accessory attachments for the unit. I would point that the second question, the only restrictions in the RV park are those contained in the PD conditions or approval of the 1994 LDC section 2.5.19.4. In fact, broadens the scope of this interpretation to beyond what the PD says. And they're asking that those are the only restrictions. Well, then that broadens the scope of this interpretation to beyond just what the PD says. Now, it is correct and is as identified in our interpretation that the terms of the PD do not address the attachments of structures nor the length of stays that are permitted. However, as we expressed in the interpretation, you also need to look to the definitions of the Land Development Code because the RV park is for a certain type of use, a recreational vehicle. And the Land Development Code has long defined a recreational vehicle as a vehicular type portable structure that are primarily designed as temporary living accommodations for recreational camping and travel use. Those are essential requirements of the use. What is a recreational vehicle? Well, that's found in that definition. And we find that long-term leases as described by the applicant in the attachment of structures to RVs are inconsistent with the 2 elements of that definition, because it's not just temporary, it's portable vehicle type structures. So we find that, again, the long-term lease as described by the applicant and the attachment of permanent structures are inconsistent with the definition of a recreational vehicle, which has been in place since 1988, prior to 1988 in the 1976 code, although the code used the term recreational vehicle, didn't actually define it. However, it did define camping and recreational equipment to include travel trailers, a vehicular portable structure built on a chassis designed to be used as a temporary dwelling for travel, recreational vacation uses, and a motorized home as a portable dwelling constructed as an integral part of a self-propelled vehicle. So throughout this, the definition has been specific to a recreational vehicle. Now, their comment that the MHP RVP district that was previously in place, when it talks about that the tenant district will provide safe, helpful living for park residents, whether permanent, long-term, or transient, I would point out that that district, MHV RVP, permitted both mobile homes and RV recreational vehicles, and mobile homes would, of course, be a permanent type or long-term type dwelling. And then finally, the question is to, why these standards are added to the Land Development Code, I think really brings us back to the nature of this interpretation, which is the definition talks about portable vehicle type structures and as temporary living accommodations. And I think that those regulations are added to the code in order to eliminate that definition and answer questions such as, because whereas I think everyone can, well, to some degree, agree upon what's a portable type structure, what's temporary living accommodation, in a regulatory setting, it's certainly very useful for everyone's benefit as to provide clear guidance on that. And so in view of the fact that the definition of recreational vehicle is always, again, talked about portable vehicle type structures and the temporary living accommodations, we feel that again, is inconsistent with the long-term stays and attachment of structures as described by the applicant, and that we believe the Land Development Code provides guidance to us to apply to this interpretation. Unless you have questions, I'm done.
Let me do this. Let me ask a question of Mr. Clark with the County Attorney's Office, if he's still here, in terms of the standards for review of the appeal from the Land Development Code. Mr. Clark, you available?
I'm here, yes.
Thank you. All right. So I've reviewed section 10.05.01 regarding appeals of the administrator to the land use hearing officer. And section E and F under that section talk about the decision of the hearing officer in writing, of course, and based on the record. But then it talks about the authority of the hearing officer upon finding of error. And it seems to me that that is the basis, as according to what I've read of the appeal that was filed. And that is a finding of error. That's the decision for the hearing officer as to whether the administrator erred in that decision. Am I reading that correctly?
Yes, correct. In the administrator's interpretation and application of the code, did the administrator err in their application of the code?
All right. Thank you so much. And so, Mr. Hisney, I have read the appeal, which you accurately described as, in my mind, two questions. One is, did they err by incorrectly applying the provisions of the Land Development Code, and the allegedly exceeded the scope of what the applicant requested as a part of the original zoning interpretation request? And to that point, I think you answered properly in terms of question 2, where the applicant states, let me find it, the question on the original appeal. One is the 400 units, and I don't think there's any dispute about that. Are there 400 units? The question was, are there 400 RV units permitted? And the administrator responded yes. The second question, because it is phrased, the only restriction on the RV park contained in these PD conditions and the 1994. So that was the question. Is that the only restriction, the PD conditions and this particular section in the 1994, Land Development Code? And so because it was phrased that way, it's your response from the staff perspective that it required more information, because the question was so narrowly constructed in terms of, is it only the conditions and this very specific section out of the Land Development Code?
Correct. I mean, there are 3 questions that they ask. Question 1 and question 3 are limited to what's permitted in the PD and an old section of the LDC. However, the middle question, the only restriction on the RV park are those contained in the PD conditions or approval of the 1994 LDC section 25194. Well, then that opens it up, and that is a very broad, open-ended question. And the answer we provided in number 2 is that the RV park is subject to the PD, LDC section 25194 was in effect, and then the LDC definition of recreational vehicle and all other applicable requirements, rules, and regulations. So whereas questions 1 and 3 were very limited in their focus, question 2 was not. It asks, are these the only restrictions? Well, in fact, they are not.
And would it be correct to say that the answer by the zoning administrator to question 2, where he adds, and all other applicable requirements, rules, and regulations, could apply to parking, could apply to landscaping, could apply to a number of
it could apply to state codes. I mean, the question is the only restrictions. Well, outside of the Land Development Code and the Zoning Code, there may be other restrictions that are applicable. And so that the question there was, again, very broad. In our response, we focused on the zoning components, which in our view include the LDC definition of recreational vehicle.
All right, and then in the zoning administrator's interpretation response number 3, the appellant has very clearly stated that they believe that the zoning interpretation should have stopped at the first part of that prior to the word however.
Right.
That because when they narrowly asked this question, there is no prohibition or limitation in either the PD or section 2.5.19.4. The administrator agreed with that, but then went on to explain the issue at hand, which is how long you can stay in an RV and so forth. But that was the reason for the however, to add that information. Is that correct?
To expound upon number 2, which talks about it being that the LCC definition of recreational vehicle is applicable to this part.
All right. And so the focus on the word temporary that has been brought up by the appellant is all a function of explaining that recreational vehicle usage and duration. Is that accurate?
Correct. And it's temporary, and also, again, as we've pointed out, the word portable is also in the definition, and the term portable is also relevant to part of the discussion here, which is the attachments. I mean, there's 2 elements here: the length of stay, as they, in their request, the length of stay, but also the attachment of things like carports and sheds, and that is relevant to the question of the definition of a portable structure.
Okay, that answers my question. Thank you so much. This appeal process, we do not take testimony in support or in opposition. Mr. Clark, did you have anything else you wanted to add before I move on?
No, nothing to add, just that this hearing itself is an appeal hearing. So the process I read at the beginning of the hearing applies to original applications such as variance and special uses. This is an appeal administrative, so this is the final internal review of this process. If you have any questions for me, Madam Hearing Officer, I'm happy to take that.
No, you already answered my question, but thank you so much. Then we'll go back to the appellant, who will have the last word for rebuttal. Thank you.
Jamie Mayer for the appellant. Thank you. The question of whether the scope was exceeded, I mean, that's really not the problem here. So we understand that there was a broader review done. The error itself is grave. The imposition of these restrictions is unreasonably depriving the owner of a vested right to use their land under the approved PD conditions. Still, we have not seen anything that shows how a definition in the code pertaining to a type of vehicle, which basically comes from Florida statute regulating motor vehicle licenses, somehow regulates a land use type that has always had its own code section. This argument, if you read the interpretation that was provided, you'll see the argument is a conclusory statement. Basically says, these uses are consistent with the definition without any evidence as to how or why that is, other than saying that it's got to do with the definition. Again, I have submitted a copy of the Florida statutes into the record, as well as my PowerPoint, and I would request that you read everything that's been provided by both the zoning administrator and us, and I think you'll find that there is actually a pretty consistent picture. The only evidence that has been provided of the supposed meaning is a subsequently enacted regulation that, quote, illuminates the meaning of the definition. That is not proper to apply subsequently enacted code to an approved PD. The approved PD is controlled by its conditions. Thank you.
Let me just, before you go, let me just clarify, because you brought up this point. So I'm reading, and I think Mr. Hisney was as well, the appeal of the zoning interpretation that was filed by the appellant, and it talks about contends that the appellant, Manatee Rv Ruskin LLC, contends that the zoning administrator erred by incorrectly applying the provisions of the Land Development Code to the subject property of the interpretation and exceeded the scope of the appellant's zoning interpretation request. So that's where that was going. So is it your testimony that you're not alleging that they exceeded the scope, it's only they erred in their interpretation?
Yes, that's what's truly at issue here. Whether the scope is exceeded or not doesn't really matter, because the result is to deprive the owner of vested property rights that by applying a code section in error that simply doesn't apply to the PD.
And that would be the definitions and the length of stay that were subsequently adopted?
Yes, by virtue of, these subsequent, very specific subsequent enacted sections are being applied. Not, if you read the zoning interpretation, it states the definition. It says, okay, the 1994 code governs here. There's nothing in the PD or the code at the time which governs that prohibits these things. But the definition is XYZ. Therefore, these things are inconsistent with that. We can look to the subsequently enacted code as to why that is. That's the argument. So really, it's with all due respect, it's kind of a backdoor way to apply these code provisions that were enacted. And understandably, it's something the county wants to regulate, but it's being used to retroactively apply them to a PD that predates them.
All right, thank you. Let me ask before we close, and I'll give you the last word after my question. Mr. Clark, can you let me perhaps could you discuss rather, code provisions that are adopted after a plan development has been approved and the plan development is silent or ambiguous in terms of a particular land development standard? Could be parking, could be landscaping, could be something. And if the plan development zoning condition is not particular or specific rather to the requirement, and in this case would be 400 units, that's very clear. What is that policy from the county? What is the legal interpretation from the county as to those code provisions that are adopted after the fact?
Without getting into, I guess, too much specificity, President Hill, I'd say in general terms, if it's an application with a prior approval, it is subject to the code provisions that existed at the time of approval. What ends up happening is the site comes in to get some sort of future approval. There ultimately would be subjected to the code provisions at that time. But if, for instance, if say, I don't use something specific but doesn't touch on the application, if you had, say, setback requirements that change in the code, any prior approvals that had the old setback are still okay. But if, for instance, a new construction comes on that site after the change in the code, the new site would have to meet the new standards. It doesn't forever vest the site, but anything pre-approved on the site would not be subject to that change unless there was some future change on the site, which would then subject it to the current code.
All right, and then thank you for that. I appreciate that. And then, Mr. Hisney, let me ask you: the zoning interpretation that was issued talks about recreational vehicles, recreational vehicle parks, and that has been a term and a land use that has been in effect since the original 1976 code. Is that correct?
Yes.
To your knowledge.
Right. Yeah. I mean, the code used the word recreational vehicles. Yes.
And then those duration of stay and the attachments to a recreational vehicle at issue of the zoning interpretation was not specifically addressed in the code when the 1983 zoning was approved. Is that accurate?
Well, in the 76 code at the time, the property was zoned to MHP RVP, and that section of the 76 code did not include things about duration of stay. However, since you say the code as a whole, there was another section of the code that was, let's see, R3 MHT, the different zoning district, but that actually did address those, but that was a different zoning district. And there it did talk about recreational vehicles and defined them in that section, not in the definitions. So the code wasn't silent, but as far as the applicable zoning district in 93, the RVP, MHP RVP, that section of the 76 code. So since you asked about the entire code.
I
So
did.
it was in there, but then, but when you looked at the definitions that it didn't define recreational vehicle in the definition section, but again, it did have definitions dealing with camping and recreational equipment, travel trailer, or motorized home. And those definitions did reference things like temporary and portable structure and things like that.
I see.
So that language was in the 76 code in the definition sections. And then in 88, the 76 code was revised to include in the definition section, a definition of recreational vehicle, and that definition has remained in the code today.
And part of the issue is in that original MHP RVP district, it included both mobile homes and recreational vehicles, hence the words permanent or temporary, because those are different.
Yes. Yeah.
Types.
Right. That district covered both mobile homes and recreational vehicles.
I understand. And so just to circle back to my original question is, this was a provision, a land use, a land use type that was contemplated and addressed in the code that was applicable when the original zoning was approved, and also the personal appearance that was modified.
What, recreational vehicle?
Yes, sir.
Yeah, well, so on the zoning history, this it was rezoned in 1983 to RVP, MHP RVP. Then in the zoning conformance process, which for this property, this section that included this property occurred in 1991. That's when it was conformed to a PD, which is how we got to a modification in 1994. During that time period in 88, yes, the definition of recreational vehicle came into the code.
All right. Thank you so much. I will give you, sorry, I'm losing my voice. I'll give you the last word for rebuttal and before we close.
Thank you. So just to address a couple of points that have been made, to be sure, the limitations on mobile home, the mobile home park and recreational vehicle park, which those two are also still contained in the same section, were specifically addressed in the conditions. So I just want to clarify that it's not that it was the PD didn't specifically address how you treat these types of uses. It did. It requires strict accordance with the code section that governs those uses at that time, which, like I said, looks very much like the section today. It just has a couple of additional limitations, which are the ones that are at issue now. And again, I mean, even the bonus provision has changed, but we still have 400 units because we were governed by in strict accordance with that very specific code section. Just to the distinction between mobile homes and recreational vehicle parks or recreational vehicles, they're both portable. We've all seen mobile homes traveling down the road, and they're both licensed. So again, permanent and long-term stays that were contemplated in the 1976 code pertain to both because they're both portable. They're both temporary or they can be permanent. And they're both regulated by statute and have to be licensed as vehicles. So, and then to Mr. Clark's point, just to clarify, no new application has been submitted for any kind of modification to the PD. So this is not a situation where we have applied for something and we're trying to, keep what we have, but also get something new. And that would mean that new code would apply, but that is not that situation. I think that's all I have. Thank you.
All right. Thank you so much. Then with that, we'll close appeal 22-0346 and adjourn the hearing. Thank you all for your time and testimony.